Hello dear students, today we will discuss acquisition under the Companies Act. The main objectives of this lecture are to study the concept of acquisition under the Companies Act, to evaluate and analyze the legal provisions governing acquisition, to analyze the power of shareholders to acquire, to study the squeezing provision relating to acquisition under the Companies Act. Dear students, an acquisition or takeover is the purchase by one person of controlling interest in the share capital or of all or substantially all of the assets and liabilities of the target. A takeover may be friendly or hostile and may be structured either by way of agreement between the offerer and the majority shareholders, or purchase of shares from the open market, or by making an offer for acquisition of the target's shares to the entire body of shareholders. Acquisitions may also be made by way of acquisition of shares of the target or acquisition of assets and liabilities of the target. In the latter case, entire business of the target may be acquired on a going concern basis, or certain assets and liabilities may be cherry-picked and purchased by the acquirer. Another form of acquisition may be by way of demerger. A demerger is the opposite of a merger, involving the splitting up of one entity into two or more entities. An entity which has more than one business may decide to hive off or spin off one of its businesses into a new entity. The shareholders of the original entity would generally receive shares of the new entity. In some cases, if one of the business units of a company is financially sick and the other business unit is financially sound, the sick business units may be demerged from the company, thereby facilitating the restructuring or sale of the sick business without affecting the assets of the healthy business unit. Conversely, a demerger may also be undertaken for moving a lucrative business into a separate entity. A demerger may be completed through a court process under the merger provisions or contractually by way of a business transfer agreement. Now, we will discuss power to acquire shares of shareholders dissenting from scheme or contract approved by majority. In general, an Indian corporation can be incorporated as a private or public company. A private corporation must have a restriction on the transferability of shares. These are restrictions outlined in articles of association of the firm and typically take the form of a preemptive right in favor of other shareholders. Although shares of a public company are freely transferable, share transfer limits for even public companies' shares have been given statutory approval with the introduction of the Companies Act 2013. The articles of association may prescribe certain procedure for transfer of shares that must be adhered to in order to effect a transfer of shares. It is therefore advisable for the acquirer of shares of a private company to ensure that the non-selling shareholders waive their rights of preemption and any other preferential rights that they may have under the articles of association. Any transfer of shares, whether of a private company or a public company, must comply with the procedure for transfer specified under its articles of association. The power to acquire shares of shareholders dissenting from scheme or contract approved by majority is covered under section 235 of the Companies Act. A company may propose a scheme or contract to another company for transfer of its shares or any class of shares. The company proposing is transferor company and the other is transferee company. 4 months' time is available for the approval of the proposal. It has to be accepted by shareholders with 9/10 shareholding in value. Within 2 months of the expiry of 4 months, the transferee can give a notice in the prescribed manner to any dissenting shareholder that he desires to acquire his shares. After service of such notice, the transferee company becomes entitled and also bound to acquire those shares on terms on which the scheme or contract the shares of approving shareholders are to be transferred to the transferee company. This effect can be prevented by an application to the tribunal by dissenting shareholder within 1 month from the date of notice of acquisition and the tribunal thought it fit to order otherwise. Where notice has been given and on an application made to tribunal and it has not made an order to the contrary after expiry of 1 month from the date of notice or after a pending application has been disposed of, the transferee company has to send a copy of the notice to the transferor company for the transfer of shares. This notice should carry with it an instrument of transfer which has to be executed on behalf of the shareholders by any person appointed by the transfer company and also by the transferee company. The transferee company has to pay the amount or other consideration for the price payable for the shares which have been acquired. The transfer company has then to register the transferee company as the holder of those shares. And within 1 month of the date of such registration, the dissenting shareholder has to be informed. The amount received has to be held in a separate bank account and then disbursed to shareholders within 60 days whose shares have been compulsorily acquired. For the purpose of section, a dissenting shareholder means a shareholder who has not assented to the scheme or contract or refused transfer shares. Now we will discuss squeeze out provisions. First, we have purchase of minority shareholding. According to section 236 of the Companies Act of 2013, if a person or group of people acquire 90% or more of the shares of a company through an amalgamation, share exchange, conversion of securities, or for any other reason, they have the right to make an offer to buy out the minority shareholders at a price determined by a registered valuer, which shall be determined based on the fair value of shares of the company after taking into account valuation parameters, including return on net worth, book value of shares, earning per share, price earning, multiple vis-a-vis the industry average, and such other parameters as are customary for valuation of shares of such companies. Alternately, the minority owners might make an offer to the majority shareholders to buy their shareholding at a price that will be decided in accordance with the established procedures. For the transferor company to be able to distribute the money to the shareholders who are eligible for it, the amount of consideration must be deposited in a bank account there for a period of 1 year. The transferor company is required to serve as the transfer agent for the purpose of accepting and paying the purchase price, taking possession of the shares and transferring them to the acquirers. The shares of a non-performing shareholder may be cancelled. New certificates will be transferred in their place by the transferor company. Once the share owner has been paid, the transaction will be recorded. The right to transfer the shares remains valid for 3 years after the acquisition date in case of deceased or non-existent shareholders whose representatives have not been brought on record. Where the majority shareholders have received a higher price, they would share it with the minority whose shares have been compulsory acquired. When the acquirer commits a violation, even though the minority shares of the minority have not been delisted and the 1 year period or the period stipulated in the regulations adopted under the SEBI Act has passed, the provisions of the section are to continue to apply. If any of the aforementioned schemes call for the acquisition of shares in a particular company by another, it may do so by submitting an offer to the transferor company and permitting the plan or contract to be disclosed to the shareholders of the target company. The shareholders have the option to approve the offer within 4 months. Approval must be accorded by at least 9/10 in value of the shares whose transfer is involved. This number must be exclusive of any shares already held by the transferee company or by its nominees or by its subsidiary. Once the approval by 9/10 majority is accorded, the transferee company gets the right to acquire the shares of the dissenting shareholders, if any. Within 2 months after the expiry of the above 4 months, the transferee company should give a notice to such shareholders that it desires to acquire their shares. Within 1 month from the date of the notice, the dissenting shareholders may apply to the tribunal. But if no application is made, the transferee company gets the final right and also becomes bound to acquire those shares on terms on which the shares of other shareholders are to be transferred. In Waste Recycling Group Re, it was held that such compulsory acquisition is not violative of human rights and fundamental freedoms. Now we will discuss fairness of takeover bids. Section 25 confers a very wide discretion on the tribunal to sanction or disallow the attempt to acquire. The two guiding principles are that the scheme should be fair and that onus lies to show its unfairness upon the dissenter. The tribunal will infer fairness from the very fact that the scheme has been approved by 90% of the members. In Tom & Long & Company Re, it was held that the proposal must be such that an intelligent and honest man, a member of the class concerned and acting in respect of his interest, might reasonably approve. The burden to prove unfairness may be reversed, where the court finds that the takeover bidder and the accepting majority are the same parties. In Bugle Press Limited Re, the scheme of takeover was adopted to get rid of a minority. The 90% majority formed a new company which made the offer and it was approved by them. Then they attempted to acquire the minority interest in terms of the scheme. It was held that burden of proving fairness lay on them, and the mere fact that the compensation was fair was not sufficient to discharge the burden. Similar to this, any attempt to force a minority to accept new obligations without their permission would be filed. A well-known authority on this is Bisgood versus Henderson's Transvaal Estates Limited. In this case, the court granted an injunction on the application of the minority shareholders, as the scheme would have enabled the new company to extract more capital from holders of fully paid shares. Inadequacy of information may be another ground for the tribunal to withhold its sanction. In Evertite Locknuts Re, however, the court refused to help a minority shareholder, although it believed with him that the information given to him was too meager, where the class of shares which are to be transferred are already held by the transferee company to value greater than 1/10 of the aggregate of the values of all the shares in the company of such class. The transferee company will not get the right to acquire the shares of the dissenting shareholders unless the same terms are offered to all holders of the shares of that class, and the holders who approve the scheme should be 9/10 in value of the shares to be transferred and should also be 3/4 in number of the holders of those shares. Now we will discuss Section 230 of Companies Act 2013. Pursuant to an application of compromise or arrangement that must be filed before the tribunal, shareholders of unlisted companies holding at least 75% of the securities, including depository receipts, with voting rights, may make an offer to purchase any portion of the remaining shares under Section 230, read with Rule 3 of the Companies, Compromises, Arrangements and Amalgamation Rules 2016. Minority shareholders would be compelled to sell their shares to the purchasing shareholder after the tribunal approves the offer for purchase. Only unlisted companies are eligible for this squeeze out strategy, and listed companies must abide by the rules set forth in this respect by SEBI. Now we will discuss scheme of capital reduction. A company is permitted to reduce its share capital by virtue of section 66 of the Companies Act. It also prescribes the procedure to be followed for the same. The scheme of capital reduction under section 66 of the Companies Act 2013 must be approved by the shareholders of the company by way of a special resolution and by the tribunal by an order confirming the reduction. When the company applies to the tribunal for its approval, the creditors of the company would be entitled to object to the scheme of capital reduction. The tribunal will approve the reduction only in case the debt owed to the objecting creditors is safeguarded or provided for. Furthermore, the tribunal is required to notify the central government and SEBI in the event of an unlisted business of the application for capital reduction, giving them 3 months to file any objections. The courts have ruled that a reduction in share capital does not have to be shared by all of the company's owners. Companies will have to mandatorily publish the tribunal order sanctioning the scheme of capital reduction. The framework for reduction of capital under section 66 has been used by companies to provide exit to certain shareholders as opposed to all shareholders on a proportionate basis. The courts have held that reduction of share capital need not necessarily be amongst all the shareholders of the company. Now we will discuss new share issuance. Section 42 and 62 of the Companies Act of 2013 together with Rule 13 of the Companies Share Capital and Debenture Rules 2014 and Rule 14 of the Companies Prospectus and Allotment of Securities Rules 2014 prescribe the requirements for any new preferential issuance of shares by an unlisted company, that is any issuance that is not a rights or bonus issue to existing shareholders. Some of the key requirements outlined in these provisions are as follows. The company must hire a registered valuer to determine the fair market value of the proposed shares. The issuance must be authorized by the Articles of Association of the company and approved by a special resolution passed by shareholders in a general meeting, authorizing the board of directors of the company to issue the shares. A special resolution is one that is passed at least 3/4 of the shareholders present and voting at a meeting of the shareholders. If the shares are not issued within 12 months from the date of passing of such special resolution, the resolution will lapse and a fresh resolution will be required for the issuance. Key disclosures regarding the issue, pricing of shares, including the relevant date of price calculation, shareholding pattern, change of control if any, pre-issue and post-issue shareholding pattern of the company, whether the promoters, directors, key management individuals propose to acquire shares as part of such issuance, etc., should be included in the explanatory statement to the notice for the general meeting. Shares are to be allocated within 60 days. In the event that shares are not allocated within 60 days after receiving the application fee, the money must be repaid within 15 days. After 60 days, interest is due at a rate of 12% per year. These requirements apply to equity shares, fully convertible debentures, partly convertible debentures, or any other financial instrument convertible into equity. Now we will discuss issue of shares with differential voting rights. The Companies Act 2013 also allows for issuance of equity shares with differential voting rights as to dividend, voting or otherwise, provided that the company complies with the rules prescribed in this regard, which require that the Articles of Association of the company authorizes issue of shares with differential voting rights. The issue of shares is authorized by an ordinary resolution passed at a general meeting of the shareholders. The voting power in respect of the shares with differential rights shall not exceed 74% of the total voting power, including voting power in respect of equity shares with differential rights issued at any point in time. The company shall have defaulted in filing financial statements and annual returns for 3 financial years immediately preceding the financial year in which it has decided to issue shares with differential voting rights. Private companies may be exempted from these requirements if their memorandum and articles of association so provide. Now we will discuss limits on acquirer. Section 186 of the Companies Act provides for certain limits on inter-corporate loans and investments. An acquirer, that is an Indian company, might acquire by way of subscription, purchase or otherwise the securities of any other body corporate up to 60% of the acquirer's paid up share capital and free reserves and securities premium, or 100% of its free reserves and securities premium account, whichever is higher. However, the acquirer is permitted to acquire shares beyond such limits if it is authorized by its shareholders vide a special resolution passed in a general meeting. These limits are not applicable in case of purchase of securities of a wholly owned subsidiary. Now we will discuss asset business purchase. Besides share acquisition, the acquirer may also decide to acquire the business of the target, which could typically entail acquisitions of all or specific assets and liabilities of the business for a predetermined consideration. Therefore, depending upon the commercial objective and considerations, an acquirer may opt for an asset purchase, whereby one company purchases all or part of the assets of the other company, or a slump sale, whereby one company acquires the business undertaking of the other company on a going concern basis, that is, acquiring all assets and liabilities of such business. Under Companies Act 2013, the sale, lease or other disposition of the whole or substantially the whole of any undertaking of a company other than a private company requires the approval of the shareholders through a special resolution. The term undertaking means an undertaking in which the investment of the company exceeds 20% of its net worth as per the audited balance sheet of the preceding financial year, or an undertaking which generated 20% of the total income of the company during the previous financial year. Further, this requirement applies if 20% or more of the undertaking referred to above is sought to be sold, leased or disposed of. An important consideration for these options is the statutory costs involved, that is stamp duty, tax implications, etc. Dear friends, in conclusion, it can be stated that Companies Act 2013 is a comprehensive legislation which contains broad and elaborate provisions regarding acquisition of one company by the other. With this, we end today's lecture. Hope you enjoyed it. Thank you.